Hi, Sam Townend here. I apologise for the delay in starting. Uh, uh, Welcome to the Society of Labour Lawyers Access to Justice and the Rule of Law webinar. I apologise again for the late start. Um, this is a very widely worded topic. Criminal and civil justice have never faced greater challenges than they do now. The system is creaking at the edges. Indeed, even 10 years ago in the last Labour government, people were suggesting the system was creaky. But my goodness, since then we've had 40% real terms cuts in the Ministry of Justice budget. And prior to the lockdown, a policy has been adopted of managing a backlog of cases. Since 2010, 25% of courts have closed permanently, threatening the principle of local justice and the accessibility to victims and defendants alike to their local courts. The number of sitting days is reduced. Successful prosecutions and penalties are down even before the COVID round, 30% lower compared to 10 years ago. And then since lockdown and the unprecedented, admittedly, difficulties with COVID, that's placed a greater strain on the justice system than ever before. Some courts and participants, and particularly practitioners, have sought to adapt and have innovated and made changes, but it has to be said they're mainly at the wealthier end of the spectrum, and others have struggled, particularly where parties have been wholly unrepresented. The anecdotal evidence, and probably some that our panel members can refer to, some empirical evidence, suggests they've been very much excluded from the civil and the criminal justice process. Practitioners have had a massive and detrimental impact, with, following the Bar Council survey, many hundreds of practitioners being of the view that they won't be holding a practicing certificate in a year's time. And despite the efforts of the Bar Council and others, diversity remains a difficulty at the bar and in solicitors' practices. Women are unrepresented in all but a couple of practice areas and take home a much smaller percentage of the money. Black practitioners too are grossly underrepresented. And I note that we are a non-BAME panel tonight, for which I do apologise. But the experience of Alexandra Wilson is not a unique one, when she was assumed to be the defendant 3 times, when she was in fact the barrister in one day. All through that, there have been many challenges, and many practitioners and others have stepped up to the mark. And on our panel tonight, we have 5 examples of that. Firstly, Ellie Reeves, who's our Shadow Solicitor General and the MP for Lewisham West and Penge. Ellie was an employment law barrister, and she's also served on the Labour Party's National Executive Committee, and as I say, is now Shadow Minister. Amanda Pinto QC is the chair of the Bar Council. When not representing the bar to government and the senior judges and others, she works in international financial wrongdoing work, corporate crime, money laundering and corruption cases. John Morgan is the chair of our junior Labour lawyers and fights for the representation of junior lawyers, both within the party and more generally. Katherine Duncan is the chair of the Young Barristers Committee of the Bar Council. Katherine's a barrister practicing in private and public law and international family law. And Rebecca Wilkie is the relatively new, but not new to, relatively new CEO of Advocate, formerly what was known as the Bar Pro Bono Unit, though she's not new to Advocate. and indeed, most recently, she's also been a programme director for the litigant in person support strategy for the MOJ, and can no doubt speak to us about that and other aspects that Advocate are fighting for. So the format for this evening is going to be that each one of our panel is going to give a short talk using their expertise and knowledge within the general topic area. And then there will be some questions, and by all means do send me questions either to my email address, which is stownend@keatingchambers.com, or indeed through the Q&A bar through the software on this webinar. And I will put those questions to our panel as the second part of our seminar. Without any further ado, I hand over to Ellie. Ellie, please do give your talk.
Thanks very much, Sam, and thank you to the Society of Labour Lawyers and the Bar Council for organising this webinar this evening. I think it's really, really important that we're holding this event and thinking about the crisis facing justice system at the moment, and I will call it a crisis because, you know, when we think of a court backlog of 50,000 cases, in a situation where there hasn't been real terms rise in legal aid payments for 25 years, we are in crisis. And the Bar Council survey, I think, really hammered home the situation that barristers and chambers currently find themselves in. I'm sure Amanda will want to talk about this, but it would be remiss of me not to. Of the 145 chambers that were surveyed, 55% said they couldn't survive 3 to 6 months, and 81% can't survive 12 months without additional financial support, and 67% of criminal chambers said that they can't survive 3 to 6 months without financial support, and 90% wouldn't be able to survive for 12 months without additional support. I mean, those are really, really huge numbers of chambers and barristers that are saying that this simply cannot continue. And things were bad before COVID. They're even worse now that we're faced with COVID. The backlog is rising. The government, whilst they've opened some Nightingale courts, they're not nearly enough to meet the demand. So there are a number of things, a number of urgent actions that I think the government should be doing, and what our Justice Front Bench have called for. Firstly, extending business rates relief to those in law that have been unable to function during lockdown, including barristers at chambers. Sam talked about the young bar, and I know we're going to talk about that in some detail this evening. But the young bar are hugely impacted by what's happening at the moment. And many young barristers have been locked out of the self-employed income support scheme. For those that have recently completed pupillage, they don't have the tax returns to show their earnings because they've only just completed pupillage. They haven't got that evidence. So flexibility in the system is needed to support the young bar, with them being able to provide proof of invoices, for example, in order to qualify under the scheme. So we've called on the government to do that, the ability to claim support based on recent invoices. One of the other things that I think the government really ought to consider is that cliff edge of 50,000 for support under the self-employed income support scheme. through my casework as an MP, I know of barristers that earn just over that 50,000 threshold, and as a result have qualified for nothing at all under the scheme. So rather than have the cliff edge of 50,000, a tapered approach would seem to me to be more sensible, and that's something that we've asked the government to look at. And also urgent provision of financial relief for legal aid lawyers, both immediate support through the pandemic with a long-term solution for the publicly funded sector, but urgent action now due to the crisis that many practitioners are currently facing. Even before the pandemic, there was a 45% reduction in prosecutions over the last decade, which has had a big impact on the publicly funded sector. But since the crisis began, many areas of legal work have been nearly cut in half. There's been a 41% decrease in police station attendances, a 45% decrease in applications for representation in Crown courts, a 42% decrease in applications received for representation in magistrates' courts. So a lot of the work has dried up overnight. And we think about those figures about chambers not being sustainable. Once we get through coronavirus and cases are up and running again, we might end up in a situation we haven't actually got barristers for people to be able to go to and instruct in order to get access to justice. So it's incredibly important that in the short term, chambers and barristers are supported so that in the longer term, we've actually got access to justice going forward. I just want to say something about diversity in the profession. It's something that I feel very, very strongly about, particularly as someone that entered the bar having gone to a South East London comprehensive school where, frankly, it wasn't really thought of that kids from my school or my area ended up going to the bar. And I'm quite conscious that we need to ensure that the bar is diverse. And I know the Bar Council has done a lot of work on this, and that's really, really important. But there's still a lot of issues to tackle, issues around diversity within the bar, and also the pay disparity that Sam mentioned about women's earnings at the bar being significantly less than their male counterparts, and earnings of Black and minority ethnic women barristers being particularly low in comparison to male and white colleagues. So I think that's an area where urgent action is needed to tackle diversity within the bar. I think I've probably gone over my 5 minutes, haven't I, Sam? So my apologies. I could go on longer, but I'm conscious that we've got a fantastic panel of speakers and want to have plenty of time for questions at the end as well. So thank you very much again for organising this seminar. And I hope that through working together, we can come up with some of the both short-term and longer-term solutions to some of these incredibly important issues, so that we maintain access, improve access to justice, and have a viable profession going forward.
Thank you, Ellie. So I call on Amanda, please, next.
Thank you very much. Thank you so much for having me. It's really a pleasure to be here this evening. I could speak about the rule of law more generally. I could talk about where we are when we don't comply with our international obligations. I could talk about attacks on lawyers for doing their job. But actually what I'm going to speak about today is access to justice in COVID. And I'm also very happy to talk about diversity in the profession and more generally in the justice system if that comes up in the questions. But I'm just going to have my 5 minutes, as it were, on the impact on our justice system of the cuts and what's happened now with COVID. So just to, without repeating what Ellie said, basically what coronavirus did initially was to halt the whole of the justice system in a kind of crisis, with courts were closed. Originally, about a third only were open to the public, and jury trials were stopped temporarily, completely, for completely understandable reasons. And indeed with some reluctance, because there was a reluctance to accept that there were safety issues in going to courts without measures being taken. Many barristers, as a result, experienced a very significant reduction in work. And of course, most importantly, many citizens stopped having access to justice. Some jurisdictions managed to get up and running remotely more quickly than others, for example, the family courts. But a third of our court buildings were open to judges and staff, in effect, so that they could continue to do hearings remotely. But remote hearings were a patchy experience, and it was a difficult situation for barristers in many practice areas, but the criminal bar probably suffered the most, because apart from anything else, the way that criminal barristers get paid is after a trial, or the end of a case that doesn't need a trial, like a plea of guilty. And if your trigger point never happens because jury trials are not happening, of course you aren't earning any money. So for the first 3 to 6 months, the Bar Council was calling on the government to give financial support to help protect vital parts of the bar. The criminal bar was one area, the very junior bar was another. And it's right to say that, for example, in personal injury work, which is not an area, as we know now, covered by legal aid, we were finding that junior barristers were just not getting, I think, sort of 90% decrease in their work because of the fact that other cases weren't going ahead, and more experienced barristers were able to keep the work that would have otherwise filtered down to them. So it wasn't just one sector of the bar that was suffering. But with great regret and very disappointingly, the government didn't follow any of our recommendations. And in particular, as Ellie has mentioned, the very young barristers that at the beginning of practice, who were amongst the most vulnerable, got no help whatsoever, even though in every other respect, other than having the tax return, they were eligible for the scheme. And I queried what it was that was actually going on in this way. It is particularly important to try to save experienced and those who will become experienced lawyers from leaving the profession, because we knew, and we know now, that legal disputes were likely to rise, and they have, and that the backlog of cases that existed anyway, and which were building up through nobody's fault, but because the courts were not operating at full speed, needed to be accommodated and serviced as well. So the risk of losing many, many members of both sides of the profession was really a significant one for access to justice for ordinary people. And where are we now? Well, COVID really shone a light on the failings and weaknesses and the precariousness of the justice system that already existed. Although we adapted quickly, for example, to remote hearings and across several jurisdictions, inevitably backlogs have grown throughout the months where COVID has meant that all courts were not operating, even at the lowered capacity that had been brought about by the lack of sitting days, which had been a deliberate political choice prior to COVID striking. So before COVID, the backlog was just under 40,000 cases in the Crown Court. Now it's about 51,500. Before COVID, the backlog was 407,000 in the Magistrates' Court. It went up to well over 500,000 in August. And it is, I'm pleased to say, now coming back down, and we're at about 489,000 as of the 25th of October, which are the latest figures. We've been pleased to say part of that conversation about how to reduce backlogs, how to get work going safely. And I think one positive out of all of this has been the collaboration between the different parts of the profession, the Ministry of Justice, HMCTS, the government, our colleagues in opposition, such as yourselves, everybody really making a significant effort to try and move things forward in a positive way. And I do really hope that that collaboration continues after, if and when the pandemic resolves itself, and we can get back to a way of operating that is more in person and with a greater throughput of cases. Obviously, we've got more and more physical courtrooms coming online, but what we have, and I think isn't really going away despite the investment in more staff, is the sufficient number of staff to cope with the increased capacity that is needed, but also the increased demands of COVID for social distancing, all of which requires a lot more staff. It requires staff to help with technology. Technology needs to be more robust. It's right to say that we put into our spending review submission that requirement, and also that HMCTS staff should frankly earn a better wage, because what's happening is that as soon as people are brought in, they get into the civil service and then they move to a better paid job that's perhaps less risky. That's got to stop. That's got to be changed if we are to keep the staff that's needed to run the courts. I've touched on technology, and I really want to be clear that technology has got to be part of the solution going forward, but it's got to be used wisely and properly. And it can't be used for all hearings to give justice. It's not just that it doesn't feel like justice, it just isn't just, for example, to tell a parent over a phone that they are no longer going to have a child live with them when that child is wrapped around its legs. That's just not justice. And what's more, we need to even out the ability of everybody to have technology that's sufficiently robust and reliable to be able to engage properly in remote hearings. Because if you don't, you will not have an experience of the court system or tribunals that leaves you with a sense that you've had a fair hearing. And that's so important. It's so important to confidence in the system. So for me, we were pleased that there was greater investment in justice, and we note that it's come in a year where there's been very little extra investment in many areas of life. So we're grateful for that, but frankly, it mustn't be a flash in the pan. It's got to be part of a long-term investment in the justice system to restore confidence in it, and that's what we will be calling for. I just wanted to end, if I may, with a couple of comments from a survey that we did. I haven't mentioned our surveys, Ellie, because you're right to point out where we were in May and July. We're about to have another survey, and I'm interested to know what the results are now, because everyone was terrified at this bleak landscape that had nothing, no real understanding of when there might be any resolution, but I think we've moved on, and so I don't want to dwell, if you like, on those previous figures personally, because I'm not sure that they reflect what's going on now. So I'm really keen that we get a better picture of what's happening now. I hope that we won't be in such a drastic position, but our Small Change for Justice report showed that justice spending in 2019 was 39p per person per day, far less than many other government departments and what other countries in Europe spend on justice. And it's declined by almost 30% in real terms per person since 2010. So it's no wonder that COVID has really brought out the cracks and the problems in the justice system. We need to restore confidence in it so that it's fair and functional. And I would suggest that coming out of COVID should be used as an opportunity to look at the whole criminal justice system, indeed the whole justice system, and make sure that it's equitable and available to everybody that needs it.
Thank you, Amanda. I think the survey, well, I certainly completed my survey, I think about 3 days ago. So it's in process. So I'm Next up is John Morgan. John, over to you.
Thank you. I have to apologise as a bit of a solicitor interloper into this bar discussion. But in the 5 minutes that I have, I suppose I want to do three things. The first is, I guess, in the context of today's sad news, mull over some of Lord Kerr's thoughts on the rule of law, and a discussion or two that I've had with him in the past on it. The second is to reflect on the importance of the rule of law in my own area of practice, which, similar to Ellie, is employment law, and in particular focus on one of my favourite judicial decisions, which is the decision of Lord Reed in the Unison case. And perhaps we can have a mull over while I do that, whether the standards set out in that case in Lord Reed's decision are being met by the government of today, and I would venture that my own response will be no, and I'd be interested to hear other people's thoughts. And then the third thing I'd want to do, and I suppose this will to some extent overlap with particularly Katherine in a moment, is discuss what the current situation has meant for junior practitioners in particular, namely what kind of profession are we creating, and what pressures have junior practitioners been placed under in the context of not just the last 10 years of cuts, but also the COVID crisis. That's a fairly ambitious undertaking, so do feel free to hurry me along or cut me off if I betray the 5-minute deadline. If I could turn first to Lord Kerr, and I first came across Lord Kerr in the context of an unsuccessful, and I say unsuccessful, wholly unsuccessful application to work at the Supreme Court as one of the judicial assistants. And during that interview, having spent a little bit of time in America, forgetting all my painstakingly assembled knowledge of public law in the UK, I meandered pretty painfully through the test for an ECHR breach. And while he very kindly indicated that the role as a judicial assistant might not be for me, something that was wholly unsurprising, there was a surprise in that he then took around half an hour to simply sit with me and discuss his judicial philosophy. And I suppose that is much to the chagrin of the interviewee after me, who was sat squirming in their seats outside the room as he listened to a bit of a monologue from Lord Kerr through the doorway. What Lord Kerr said in that, and I think it's pertinent to today's discussion, is that he considered the role of a judge to be very much somebody who's tasked by the other organs of the state to be searching for the right answer, rather than somebody who independently is off looking for the right question to ask. And I think that's a very everyday way, actually, of setting out what we're all here to talk about today. Judges act to defend the existing, and I think existing is the important word, the existing rights of everybody within society. And that's something that the executive has as many chips on the table as the everyday citizen in ensuring maintains to be the case. And he also, I think, ended actually the discussion, I have this scribbled in my notes, he ended the discussion referring to the also late Lord Bingham, talking about whether the and I think the quote was that denial of legal protection to a poor litigant who can't afford to pay actually undermines the entirety of the rule of law. Now that's I promise you it made sense in the context. I can't quite remember what the context of that quote was in the discussion, but again, I think that's central to today, where we simply see that ideal is not being lived up to, following 10 years of austerity and a pandemic. If I turn now to Lord Reed in the Unison decision, and this is a decision that I'm sure many participants on the call today have read, one or two may indeed have participated in the litigation, or so I'm told. And if I could summarize ever so briefly, it was essentially an administrative application against the imposition of employment tribunal fees, which you may remember cut a swathe through the employment bar and the employment legal profession around the middle of the decade. The petition before the court, and I won't get into the detail, was essentially that the unlawfully prevented or restricted access to justice. And And it's that confluence of my own area of practice, employment law, where really you've got as big an imbalance of power as any that exists within legal interactions between individuals, alongside a very considered response by Lord Reed of what the access to justice meant. And if I don't think anybody can do a better job, and this is a bit of a cop-out, but I don't think anybody can do a better job of summarising the perspective than Lord Reed himself. So I'll just perhaps read a couple of sentences from the decision. While I'm reading, I think perhaps if we could consider whether, in the context of these years of cuts to legal aid, cuts to the court service itself and the closure of courts, the ever-increasing backlogs and the servicing of cases, and that's not just before the employment tribunal, but before regular courts too, and the pressures faced by the voluntary sector on legal advice and representation, whether really we're falling into this pit as Lord Reed described it. So he has it as so. The constitutional right of access to the courts is inherent in the rule of law. The importance of the rule of law is not always understood, and he was very kind to explain to the executive what that meant in the decision. Indications of a lack of understanding include the assumption that the administration of justice is merely a public service like any other, and that courts and tribunals are providers of services to the users, quote unquote, who appear before them, and that the provision of those services is of value only to the users themselves and to those who are remunerated for the participation in the proceedings, i.e. yourselves. The extent to which that viewpoint has gained currency in recent times is apparent, but access to the courts, he went on to say, is of value not only to the particular individuals involved, but society as a whole. And I think we're forgetting that nowadays, if I could be so bold, where really the justice system, as Amanda and Ellie have described with reference to a multitude of reports, multitude of experiences, the justice system is being treated like any other public service. It was not ring-fenced in the same way as other crucial public services through spending cuts, and really it's been cut away at through cut after cut, tiny cut after tiny cut. So I'll perhaps take another minute to summarise ever so briefly, if that's okay, if I can seek your indulgence, on the impact on junior practitioners. So I come from a large commercial firm, actually, and I think perhaps my own experience, and then I've sought discussions with a number of our members in preparation for today's session. And I think the broad parameters of what came out of that were that actually the junior profession exists in the same way as society as a whole at the moment, in that there is ever increasing inequality. Commercial firms are doing ever so well. Those who did freeze pay or indeed implement pay cuts have now decided, in fact, having reflected, that they've done rather well out of the current situation, and work has been busier than ever, and so they can in some cases even grant bonuses to their staff as a result of the work that they put in during the pandemic, and clearly in many cases merited, because the work was particularly brutal. But that inequality exists as it exists elsewhere in society, because we've got that cozy 1 or 2% at the top who are doing rather well out of everything, with the vast majority of practitioners, and this isn't just legal aid practitioners, but practitioners across the remainder of the profession, simply existing in a much more hand-to-mouth existence. What that does is it's created a bleed from the criminal bar in particular. I'm sure I won't need to tell many participants about that. It's also exacerbated across a large proportion of the junior profession, and both solicitors and barristers I include within that. It worries about job security, financial worries, and that's particularly, as Amanda mentioned, the very junior bar being those who are most fiercely affected by the failures of the Chancellor to extend proper support to the self-employed, and also where in certain specialisms there have been insolvencies or redundancy programs within law firms. We're seeing as much as last in first out as apparently gone the way of the dodo, inevitably there are certain low-hanging fruit within organisations that can be cut away at. So I suppose I think I've, like any good speaker, I've taken up too much time. What I'll perhaps end on is a recommendation for 2 bits of further reading, a bit of an academic at heart. The first is a TUC report covering the Speak Up for Justice campaign, and that looked at the impact on the legal profession as a whole, and particularly the impact on junior and minority practitioners and service users, and they did frustratingly that was a term that came across. And then the second is, and this is something that a number of my colleagues contributed to, the Society for Labour Lawyers report on the impact of COVID on the justice sector and just the judicial system more widely. Again, a great report that I can wholeheartedly recommend. So yeah, look forward to questions further down the line, but I think I'll pass back now to our host.
Thanks, John, and thank you for the advert for the pamphlet that was produced by the Labour lawyers, which is, I think, on our website, which I'll refer to at the end. Now, our next speaker is Rebecca Wilkie, the CEO of Advocate. Rebecca, over to you.
Thank you very much. Good evening, everybody. I feel I should declare myself similarly in John's camp, I'm afraid. I'm another solicitor interloper, but a former solicitor, and I'm now a proud CEO of Advocate and also a trustee at Money Advice Trust. I'm not speaking for those organisations, so just to make clear, I'm speaking in a personal capacity this evening. And I want to spend the next 5 minutes really talking about the challenges for access to justice that have arisen from the pandemic for pro bono services in particular. So for those who can't afford a lawyer and aren't eligible for legal aid. And I want to cover 2 things. Firstly, how our service and the wider sector has had to adapt. And secondly, how we're trying to meet demand with the bar's support. So in March at Advocate, we transformed in a matter of weeks from being a paper-based service to digital. And this was essential. Firstly, it meant staff were able to work from home and barristers could volunteer remotely. But key was making sure we remained accessible to the public. It enabled people to access our services remotely, removing the need for them to visit an advice agency to act as a referrer to us. This was crucial not only to help people who were shielding, but it meant we were accessible in national lockdown for those who either couldn't leave their homes or also had experienced the closure of face-to-face services. And that inevitably brought and continues to bring challenges. And just in the interest of time, I just wanted to highlight a couple of those to you. So without a referring organisation, we find applications to us now often have limited supporting documents. They require much more hand-holding from our caseworkers through the process because people just don't know what are the correct documents they need, how to identify them. And because that takes longer, helping them to identify those papers remotely, it means there's therefore less chance of us trying to place the case before a hearing deadline. We find applicants with complex legal cases, they have hundreds of pages of court documents who can't afford to post them. And whereas previously they might have been able to access libraries or similar frontline agencies to help scan the documents, those have now closed, so people aren't able to get those documents to us. And issues of comprehension, again, without the intermediary of a frontline agency, people being at home on their own, particularly where English may not be their first language, they can maybe start to understand it if our casework can spend a lot of time on the phone talking them through it, but otherwise it's creating another barrier for people. So what are we doing to adjust? Well, the main thing is, as I said, it's just taking longer for us, our team, to really try and help people effectively, particularly for those who either don't have digital access or totally understandably are really struggling with it. We're trying to support clients with mental health problems which have been exacerbated by lockdown, and particularly as they don't have the usual support structures like family members to call on. And this has had a knock-on impact on staff. And I think that's something where there is widespread concern about well-being across the entire advice sector about that, and certainly into other sectors as well. And even just speaking to our team about the behaviour of our applicants, seeing how that has changed. It was described by one, they said, our callers are 100% in a more desperate, vulnerable place. You can tell by emails and calls, they're feeling lost within the system that is now being adjourned or taking place remotely, not understanding whether remote is better or not. And I thought what would be helpful perhaps is just to focus particularly on the employment space. John and I didn't prepare this beforehand, I should quickly say, but just because this feeds into some information we heard from the Employment Legal Advice Network, which represents 40 organisations, and a couple of things which they identified earlier this year was firstly the know-how gaps in the advice sector. So the larger law firms often have know-how lawyers who are kept really busy at the outset of the pandemic, with new employment guidance being released almost weekly at one stage. The advice sector simply, we just don't have this resource. So on top of running advice lines, managing clinics, casework, it was really difficult to keep abreast of the speed of developments which are relevant to the vulnerable workers they support. The good news was that actually the network ran a series of training sessions with pro bono barristers from Cloisters and lawyers from Allen & Overy. But they also spoke about the difficulties of reaching clients. So most of the network provided walk-in advice clinics, and overnight, as did many people, have to make these types of shifts. We're required to think of different ways of delivering these services. And a lot of people have then noticed a real shift in the client base. So although numbers were up, actually the makeup of the numbers was very different. And again, sector-wide, people are concerned about the disappeared clients. People who ordinarily were accessing services no longer seem to be doing so. So how are we trying to meet demand with the bar's support? Well, first and foremost, particularly in this session today, I think it's really important to acknowledge that we understand this is a drop in the ocean. We fully support a properly funded legal system that enables access to justice. But we recognise that pro bono is critical for those people who will otherwise fall through the cracks. These are people who will otherwise be on their own in the legal system, and the people that Advocate was designed to support when it was set up almost 25 years ago by the bar. Demand for our services has increased, so by 20% this year, we see the numbers still continuing to rise. But the readiness of barristers to step forward during the pandemic has been deeply impressive, and particularly, and I think Katherine and Amanda saw this when they were judging our bar pro bono awards, but particularly the younger bar, it was just incredible, the speed with which and the willingness with which they were doing pro bono cases when their own caseload had been impacted by it. We had 436 new volunteers sign up in this year alone compared to 250 last year. And we're placing a record amount of work. So by the end of October, we've seen a 53% increase compared to the whole of last year. Interestingly, we talk about technology. We found the use of remote hearings has really increased our ability actually to find barristers to provide representation. So finally, we can try and match people in need of help with barristers all around the country. And until then, we've been really limited either by searching for barristers local to the court where a hearing was taking place, or one of the barriers being that barristers who may be able to willing to accept a pro bono case just being unable to pay the extensive travel costs in order to get to the courts. So where do we go from here? Well, one of our panel members, I think, summed up the challenge genuinely earlier today in an email I received. I always think it sounds a bit sketchy when people say that, but we genuinely did receive it earlier today, when he said, "I cannot imagine how our applicants cope without legal assistance, particularly with life turned upside down with COVID-19 and cases being delayed alongside changes to procedures and guidelines." There are still cases we are unable to place. We're seeing an increase in employment, family housing. We're seeing relisted hearings coming thick and fast with a shorter notice period. So as we approach our 25th anniversary next year, we're bracing ourselves in light of the ongoing challenges, but feel very fortunate to have the bar alongside us. Thank you.
Thank you very much, Rebecca. A lot to think about, and of positive news from the bar, but it's obviously a symptom of something else as well, isn't it? So then finally turning to Katherine. Katherine, over to you.
Thank you. Yes, I represent the Young Barristers Committee. I'm the chair of the Young Barristers Committee, and I'm also the second Scot you'll hear from this evening, which makes a really nice change. Very refreshing to hear from John there. So this year, alongside the publicly funded bar, the Young Bar has been the most badly hit by COVID-19. So to give you some idea of what the Young Bar is, we represent all barristers in their first 7 years of practice. And so that's about 3,000 barristers. And about half of those barristers do crime. So the interruption to jury trials has significantly hit the Young Bar. And even those who don't do crime, the interruption from COVID significantly hit the Young Bar too. Only 30% of the young bar thought they would still be working from their current chambers in a year, and that was from the Bar Council survey in July this year. Why the young bar is particularly vulnerable is because we work from brief fee to brief fee. We often have very large student debt. We have minimal contacts within the profession in order to sustain our practice, should we lose one contact from another. We have very limited savings to fall back on. And so when the work dried up overnight and we just had no idea when it would return, a lot of work was done on civil legal aid to get payments prior to the end of a case. You heard from Amanda earlier about those who practice in crime don't get their fees until the case is billed at the end of the case, or if, for example, a defendant has pleaded. There was work done to ensure that there'd be hardship payments for those practicing in crime, but that didn't really seem to make a huge amount of difference to the young bar. When we did complete our survey, and I won't dwell too much on that survey itself, but I do want to say that 67% of young barristers had suffered a drop in income of over 50%. And for 43% of young barristers, that was over 70%. Remote working has worked well in some areas, although remote working has not necessarily trickled down to the young bar in all practice areas. Frankly, the attractiveness of a young barrister is that we will go to the middle of nowhere in order to do a single case. But if you now as a solicitor can line up 5 cases in a day from where you are sitting at home, there isn't necessarily that need in order to instruct junior counsel to attend a hearing if a solicitor can cover it themselves. And so that was really felt by the civil bar and particularly when the lockdown started. I'm pleased to say that while that may have been the initial picture, that work is now starting to trickle down to the junior bar. But again, it depends from practice area to practice area. Amanda spoke about how family law was able to get up very quickly with remote working. I'm a family barrister myself. However, even within that, there was differences. So many private law cases, those concerning parents who can't agree where the children lives and what time the other parent spends with them, many of them went to mediation or ADR for quicker results because they just couldn't get a hearing listed in the court. And that work doesn't tend to go to young barristers. Finance cases were adjourned for a very long time, often with no end date about when they would be relisted. Feedback from the administration bar, the Chancery Bar and the Property Bar was that county court work reduced significantly and the delays in listing meant a reduction in income for young civil practitioners. There was also a disparity because young practitioners tend to cut their teeth on things like landlord and tenant work and are in the county court maybe 3 times a week, and that's how they generate their income. Whereas the more senior you get in the profession, the more advisory and more paper-based your work is. So while senior members in those areas could continue to a large extent as they were doing before because of the nature of their work, the work that junior practitioners cut their teeth on had again dried up overnight. We saw that a number of chambers then were very nervous about whether to take on pupils, whether pupils were had sufficient court experience in order to give them tenancy decisions. And about 41% of chambers with pupils said they would not be able to make tenancy decisions because they just didn't feel the pupils had had enough court experience. I really hope that we can improve on that figure when we get the results from the next survey. Thankfully, no offers of pupillage have been withdrawn, but we know about 25% of those who offer pupillage have delayed the start date of their pupils, again, because they're just not sure that the work will be available for them, as well as implications on finance for funding the pupils themselves. A lot of the work that the YBC has been doing this year has been focusing on sustainability of the profession and sustainability of diversity within the profession. The young bar is the most diverse sector within the bar. Ellie mentioned that there are real concerns about the disparities in pay between men and women at the bar and white barristers and barristers from ethnic minority backgrounds. The recent BSB report shows that women are significantly overrepresented in the 3 or lower income brackets and significantly underrepresented in the highest 4 income brackets. And there are significant differences between the income of white barristers and barristers from ethnic minority backgrounds. Barristers from ethnic minority backgrounds are overrepresented in the lower 2 income brackets versus white barristers. and the differences between groups are starker if gender and ethnicity are examined together. For female barristers from minority ethnic groups, 44.9% are in the lowest two income bands. This is more than double the proportion of white male barristers. So one of the aims that the YBC has is trying to level the playing field by supporting the young bar in early career advancement. Research undertaken by the Bar Council at the beginning of the year has shown that early career advancement is an essential element of a thriving practice and has significant impact on future success and retention. But what we find is that there's a real lack of transparency about how you progress in your career once you've got tenancy. There's a very clear structure about how to get pupillage and how to get tenancy and what you do. But after then, there's not really anything between getting tenancy and either going to the bench or getting silk. And so this lack of transparency tends to favour those from privileged backgrounds who have access to networks and have been taught a skill set, which means they're more likely to get higher paying, better quality work quicker. And so what my committee is looking at is what policies or skill sets can be put in place to make career advancement more accessible and transparent, and particularly around issues around work allocation, for example. And I hope that we'll be continuing to have uncomfortable conversations if necessary about institutional changes that chambers and workplaces can make to improve and sustain diversity. It's obviously been a really challenging year for everyone, but the bar isn't so unique and special that it's immune from change. The lockdown this year has forced us to work in different ways. Sometimes that's completely changing how we work. And I really do think that the young bar has risen to the challenge. The young bar is really enthusiastic. It really wants to work hard. It just needs to be given the support in order to do that. And I really hope that's something that we can discuss further.
Thank you very much, Katherine. I hope that will also be something we can discuss further tonight. But I have got the first question, or rather it's two questions from two contributors which touch on the same general topic, and they refer to the Legal Services Board report, the State of Legal Services 2020, which says that despite its fundamental importance, the debate over the publicly funded legal system sometimes masks the fact that there are significant access issues for population groups and areas of law that would be unlikely ever to be within the scope of even the most generously funded legal aid scheme. Now, Stephen Hockman in his QC, in his question, which you probably can see, says that as the speakers have said, the post-COVID survival of the legal profession is a necessary precondition for preserving access to justice. However, the recent paper suggests that there are other necessary preconditions. They point to the underlying unmet need for affordable legal services in many areas, a need which prompted the creation of the Society of Labour Lawyers itself more than 70 years ago. Do the panel members have thoughts as to how society can address this intractable but vital social issue? And another contributor, Richard Lomax, gave a specific proposal, which in fact reflects one that was in a Society of Labour Lawyers pamphlet from 1964, which proposed essentially state-funded salaried lawyers in law centres throughout the land. Would the panel agree that the Legal Services Board report is right, that we cannot expect legal aid ever to meet its promise? Isn't it time now to abolish legal aid and direct public funds into a national legal service, an equivalent to the NHS, thereby providing a statutory right to ensure fundamental rights are enforceable? Well, a very fundamental change proposed, but an open question from Stephen Hockman. I don't know who wants to tackle this wide topic first, but perhaps Amanda, could I ask you to give us your thoughts?
Yes, well, thank you very much for some incredibly detailed questions to kick us off. Can I just say this? I'm giving my own views, and I've absolutely no idea if the rest of the Bar Council agree or not. I don't believe that the idea of having a sort of equivalent of the NHS in legal services would be a good idea. And I don't think it would be a good idea for a number of reasons. But one is that it will become unwieldy and I suspect, bogged down in management without really delivering access to justice. And what we really need to be thinking about is what are the mechanisms by which people can access justice in its widest form. And I know that many people on this at this call or conference or meeting will have heard Professor Susskind talking about using technological solutions to some people's legal issues, and I see that there is a place for that, as well as other mechanisms. I mean, he talks, for example, about unmet need being dealt with by technology in a way that they would never need to use a lawyer. I'm not in favour of having lawyers for the sake of lawyers. I'm in favour of having lawyers to help people navigate their rights and make sure that they can actually enforce the rights that they have. And I think there is something to do with, and this isn't really a structure, but I think this is a really important point, and it actually came up in the Bar Council in a session we did at the first ever Bar Council Book Club, which was to talk about the use of language in the law. If you've got very complicated language and you've got very complicated procedures, the whole idea that you can understand what you can and cannot do is made so much more difficult for you. And I think Rebecca's really touched on that, sort of perhaps tangentially, when she's talked about people saying, I don't know how people would manage if they didn't have pro bono representation, because they don't understand what the issues are that they have, let alone go to the right lawyer. So for me, one of the answers isn't to make an enormous sort of behemoth, but to give people more access to early legal advice. That to me is a really fundamental way to deal with the issue of people not being able to understand what their rights are, but also to be able to exercise them.
Thank you, Amanda. Rebecca, I don't know, you were cited there. I don't know if you would have anything to add or respond.
Yes, no, I agree with Amanda. I think the idea of doing some fundamental kind of trying to restructure everything, the kind of cost and time and everything else that would entail, when at the moment we're just faced with such kind of levels of demand as it is. I think it's trying to make the best of what we have at the moment. And I agree with the kinds of points which Amanda has made. I think more access to early legal advice has to be crucial. The amount of times people are coming to us, and actually know, had they actually known that early on they were able to identify that there was a legal issue and there might have been an alternative solution, it would have saved them an awful lot of kind of emotional cost as well as financial costs, where maybe they did have some savings there. So I think we need to encourage people to try and get help early. I think the use of language is so important. So Advice Now and Law for Life, Law for Life's the name of the charity, they do a lot of work around public legal education, but also trying to work with HMCTS and others around the use of plain English. I think the amount of time that's spent with people just trying to get to grips with this extraordinary complex legal language could just be avoided. And there's work going on there. So I think there's work to build on. But also, interestingly, I think that idea of tech solutions, I think you can combine it in quite novel ways. So, for example, and I think that's around the affordable advice issue, I think what we recognise, there are some people who may have a bit of money that they'll be able to use to pay for a lawyer, but they wouldn't be able to pay for a whole case, but they have no idea where's the best place to try and spend that money. So Law for Life have done a really interesting pilot with Resolution. And what they're doing, they have quite detailed family guides to help people through a family case. And at various points in this family guide, which is a self-help guide, they will say, now you might like to think about trying to get some help at this stage. You're then forwarded to a list of resolution lawyers who've all given a fixed cost for the amount they would charge to do a particular piece of work. So you may be able to get that small bit of legal advice at that stage, but then the solicitor then refers you back to the self-help guide to go through the next bit of the case on your own. So I think there are interesting things there that are taking place and more to be done.
Can I just come in on that, Sam, if that's okay? absolutely echo everything that's being said about early legal advice, because what we tend to do is we wait until there's a crisis and then we try and spend way more money trying to fix the crisis than if we could have dealt with the problem at the beginning. And as well as early legal advice, what I would also make a plug for is some joined up thinking with the education department as well, because it's not just about having access to the early legal advice, but it's knowing that you have a problem in the first place. So what happens is that people don't know that they're in a problem until there's problems with benefit entitlement, debt, employment, housing. They don't know who to go to advice for. Teaching people things like how to write a letter or how to make a telephone call or how to go to a library if you can, and how to use a search engine to find the person you need in order to say that you have a problem. These are all life skills that a lot of the time aren't taught to people. And so people don't know they're in a crisis until it's too late. It tends to be the things, I'm sure Ellie will agree with me, that people turn up to the offices of their MPs with a plastic bag of papers saying, help me. But by that point, they're in crisis. So as well as access to early legal advice, I think there's a lot that we could do to look at education in the country, to educate people about their rights, about basic life skills in order to enforce those rights and to get access to the help that they need. And I think a secondary aim of that is that there's more that we could do in schools about the importance of the justice system, about accessing your rights, about the importance of it as a limb of democracy. Because quite often what I think society does is it views justice as very much as crime, and that's the only thing. And that you don't really need a lawyer or you don't need the justice system unless you do something wrong. And I'm not going to do anything wrong because I don't need to know about it. But if there's more done at early level as well about people's understanding of the need for a justice system, then that's more likely to improve the political will in order to put more money into the justice system. Because at the moment, if you have a population who doesn't necessarily see the need for it, there's no political will to put more money into it. And part of that means educating people in school and adult education about the importance of it.
So Ellie, restoring green form legal advice money, legal aid, and also legal education, rather than structural changes, what do you think?
I mean, I think that restoring early legal advice is absolutely key and fundamental to all of this. I mean, I've raised this in Parliament on numerous occasions from the backbenches. Before I became Shadow Solicitor General, I was on the Justice Select Committee, and this issue came up time and time again. And it seems to me it's really short-sighted not to have early legal advice. And I say that as a lawyer and also as a member of Parliament. If someone has access to early legal advice, often it stops their problem from escalating and becoming a much bigger problem than it ever would have if they'd had access to the advice in the first place. So thinking about a benefits issue or a housing issue, if someone gets access to the early legal advice, it can be resolved at a much earlier stage rather than it escalating, potentially someone losing their home, experiencing health issues as a result of having their benefits taken away from them. A whole range of issues can occur because someone hasn't had access to that early legal advice. So actually it can save money in the long term because it stops people from going into crisis and their lives spiralling out of control. They're losing their homes, their health deteriorating, and all of those issues. It will save the NHS money, it will save adult social services money. I really strongly believe that. There's also another point as well. People don't get access to legal advice. You have a situation where the courts end up getting clogged up with litigants in person. I know from when I was in practice, I would very often have to tell people that came to me, and I represented trade unions and trade union members, and people would come to me and I'd advise them on their prospects of success on a claim. And you take the time to meet with the client, go through it with them and advise them. And employment law, such as it is, means that very often you're advising them that their unfair dismissal claim, for example, was unlikely to succeed in tribunal. But once they were set out for someone, 9 times out of 10, they'd be satisfied with that advice, that they'd been listened to, they'd had their voice heard, and they'd got a reasoned advice as to why it probably wasn't a runner in that particular case. And they wouldn't litigate themselves. But absent getting that early advice, actually people think, oh, I've got a great claim, I've been treated really badly. You might have been really treated really badly. It doesn't mean you've got a legal case. People would think, I've got this great case, I'm going to go to court on it. And actually, they haven't got a great case, and they end up getting sort of stuck in the court system, and no one has actually ever sat down with them and said, your case isn't actually, you've been treated very badly, but legally it probably hasn't got merit. And it clogs up the court system. And I think that's a real issue as well. So to me, not having early legal advice is short-sighted, and causes a great deal more problems, in my view. So, but very strongly think it needs to be restored. There was a second part of that question as well, I think, Sam, wasn't there? Public legal education, yeah, again, really important, and something that I think needs to be rolled out.
John, I know you wanted to come in on this one as well.
Yeah, it was just to mention that as the SLL, we're looking at collaborating with a number of third sector organisations, and Rebecca might be in touch afterwards, around a project of public legal education. So we've already spoken with a few, but that'll be something we might follow up on in due course, if that's all right. If I don't know if you want me to talk about the idea of the National Legal Service as well, Sam. Is that okay for a moment? I think my natural instinct is actually to have something where I can have something as a public service. I probably want it to be. And I had to almost talk myself out of it on principled grounds. And really, the concerns I had with it were around questions about independence and impartiality. If it is very much a publicly employed lawyer, rather than simply the public purse distributing funds to a lawyer, then you've got one less layer of protection away from political interference or even just it being seen as questions of political impropriety for a case to be taken or not taken. I think I'd probably also be concerned about, again, throwing such a service into the quagmire of tabloid reaction in the way that legal aid decisions have already been faced with over the course of the last few decades. If the Daily Mail is going to kick off about an individual receiving legal aid funds, I can only imagine what the reaction would be if the government themselves were seen as, and this is how they would construe it, the government themselves were seen as helping such an individual. So I think on pure practicalities, I'd probably veer away from a national legal service, as attractive as the principle is. And probably, and this ties back to my response in the first round of talks this evening around the trying to redress the inequality in the profession, where we have a number of bodies who are doing really rather well out of the way that the profession has grown up, but a large proportion of practitioners and therefore their clients not doing quite as well. And so I've been thinking a bit of blue sky thinking about some kind of solidarity levy, and that doesn't necessarily need to be. I can feel my boss on my shoulder at the moment telling me to stop talking, but it doesn't necessarily need to be in the form of a tax on profits. It could in fact be that a certain proportion of hours, for example, are required of, and indeed a higher proportion of hours than is currently the case in some of our jurisdictions, is required of individuals or some other form of levy that encourages a bit of solidarity between the different wings of the profession. And like a number of people have mentioned, encourages a bit of knowledge sharing where large firms have these incredibly well-resourced knowledge banks. To a certain extent, they might be able to use them for the benefit of a wider proportion, a wider cross-section of society, rather than just their well-heeled clients. And I think if you were to levy that in the form of a tax, you might want to use that to pay for local law clinics, Citizens Advice Bureau, etc. And if you had problems about putting that into the general funds of the Exchequer, why not give all the money to the Law Society and get them to run a network of advice centres? But I think, yeah, I think the main difficulty I have with the current system is just that inequality within the profession. There's a number of people doing very well, a number of people not doing very well, and anything that seeks to improve the outcomes for citizens that use the system probably has to at the same time try and tackle that vast inequality of resources between rich and poor. Bit of a lefty answer, that one. Sorry.
So my next question is another detailed question arising out of events of yesterday and falling in the general remit of this talk on the rule of law. But in 1989, Pat Finucane was murdered in Belfast. The Cameron government, it had an inquiry, internal inquiry. Desmond de Silva QC investigated it and established that there was collusion and state actors were involved. Yesterday, Brandon Lewis, the Northern Ireland Secretary, accepted that state collusion to some extent was involved, but rejected the calls for a public inquiry at the moment, citing that the police investigation should take its course. But the Belfast police are reported of saying that there's no live line of inquiry. I wonder, and this is an entirely voluntary question to any of our panel members, whether you have any thoughts or comments, but it certainly struck the questioner and indeed me that it is something that is worthy of a public inquiry, and now is the time, it being 30 years since his murder. I don't know whether Ellie, do you know if your Northern Ireland colleagues have looked at this question yet?
I don't know, actually, Sam. I can check, but I don't feel as though I should speak for our Shadow Northern Ireland front bench, if you don't mind. But I'd be happy to check, because I think it raises some very important issues. Yeah.
Okay. Well, the last question, which I was able to circulate to you before, which is in relation to positive policy proposals, and we've already talked about legal education and restoring effectively the green form legal aid, perhaps widening it. I just ask each panel member to name one policy proposal beyond simple restoration of funding to 2010 levels that you'd like to see it implemented, and what impact would you see it having? Rebecca, I wonder if I could ask you to go first on this one.
Yeah, I think from my perspective, I think there's something around seeing the extension of digital access, the speed with which that's now happening, really making sure there's provision of assistance to those who are digitally excluded. I think there's a real risk that a whole swathe of people are going to get left behind. And I think there can be an assumption which, great, everything's online, doesn't that make it easier? And actually, yes, for some in the population, it absolutely does. For others, it absolutely doesn't. And we certainly see it with the people who are trying to access our services. They're finding it hard enough trying to deal with their own legal case. But on top of that, things like the difficulties with electronic bundling and the types of issues that go with trying to use the technology creates massive challenges and barriers. So I think having, really trying to focus on, well, what does that assistance actually look like to people, and making that guaranteed in some way would try and make sure that there's a more level playing field, because otherwise I think the most vulnerable users of court services will be just left behind.
John, could I ask you to make your suggestion?
Of course, other than my madcap proposal for a new tax on lawyers, which would make me incredibly popular, I think running on the same line as Rebecca, I think the use of technology is probably the key line that I think is crucial in improving the situation. Where I think there's already existing good practice in a number of areas, and it is about information sharing about the best use of technology. There are a couple of jurisdictions, even the employment tribunal is relatively good in some ways, and it just those good practices aren't necessarily replicated across the justice system. So it would be to encourage the various actors to spread best practice across the sector in relation to the use of technology.
Thanks, John. I mean, for my two penneth, we talked about the use of language and making that more accessible. I also think we should try and simplify and certainly reduce the sheer number of changes and complexity of our civil procedure. I mean, we have a doorstop every year, and it's hard enough for full-time barristers to keep up with it. How it is possible for anyone else is beyond me, I have to say. Katherine, over to you.
I apologise. I'm going to go very, very granular with my answer to this question, but I hope it can then be used as an example of other ways that we can look at moving away, when necessary, away from an adversarial approach to courts when it's appropriate. And so to do that, I want to focus on the example of the family drug and alcohol courts pilots that were run in London. They're very different from normal courts, and they're very different even from care proceeding courts. The judge holds fortnightly reviews with the parents in care proceedings themselves, in addition to the usual court hearings with lawyers, which are held kind of monthly every 6 weeks. It's a really specialist approach designed to get parents to reduce or to abstain from substance misuse. It looks at getting a whole bunch of professionals involved with the parents, not just lawyers and social workers, but psychologists, psychiatrists, substance abuse workers, and provides an intensive treatment and support to those parents wishing to turn their lives around. And so the court goes from being one side saying one thing versus another to how can we kind of problem solve this situation and make it better. And it's much more of a firm focus on working positively with the parents. The pilots that have been run, and they were brought in kind of, I think, 2014, 2015, there was then a kind of scale back of the funding, and it looked as though they were going to be closed. And I'm pleased to say that they were kept open, but I would make a plug for them. When they were evaluated, more children were found to remain with their parents than in comparison with with care proceedings. And 35% of mothers in those courts stopped misusing drugs and were reunited with their children, compared to 19% of comparison mothers. And over the 5 years, not only are the outcomes better for the children and their families, but they also save significant amounts of money compared with care proceedings as well. So the financial savings was over 5 years was 729,000, which equates to about £15,850 per case on average. Keeping children with parents who care for them in of themselves is massively important. But again, it also saves taxpayers huge amounts of money from having the cost of keeping a child in the foster care system until they're 18. And we know that those children who do end up in the youth justice system are most often from the most challenging families and have had some involvement with children's services. So the more that we can do, again, it comes similar to the point we made about early legal advice, about getting things in the beginning before they become a crisis, and how one thing can lead to lots of different problems in lots of different areas and causes more money in lots of different problems in lots of different areas. This is one initiative that is saving a huge amounts of money and is doing really good work. And I would make a massive plug for in a personal capacity, not as chair of YBC.
Thanks, Katherine. And I'm sure Ellie would welcome if you were willing to put down the proposal in writing on a page or two, so that she can take it on. Amanda, over to you, please.
Thank you very much. I mean, I just want to pick up, actually, if I may, two points which follow on. One from early legal advice, but the other from what Katherine's saying. And I think what they demonstrate is that if you give people help at a point where they can't necessarily identify what the problem is, or the way out of the problem, then not only do you help them and not leave the thing to escalate, but you help society generally. And what Katherine didn't really talk about in one way, but is an obvious and known repercussion of children going into care, is that their life prospects are just worse. So if you can stop that from happening, however difficult a family life is, when everybody is working to support that family life, what you're doing is creating a better citizen for the future, and that's got to be better for everybody. And I just wanted to come back, if I may, to some sort of specific aspects of early legal advice that we put actually in our spending review submission. But one is legal advice for social welfare issues, and again, it comes down to the same point, really, where people are not necessarily knowing what their rights are. What you're actually doing is preventing something from becoming an intractable problem, and one which is likely to have repercussions across lots of different government departments. And I think what we need to perhaps do is to step back and stop looking at things in such a siloed way. So whereas I am not in favour of a sort of national legal service, I am in favour of enabling people to have a way of limiting problems that will have positive effects across lots of different government legal departments. I mean, listening to Katherine, you'd have thought it was a no-brainer. and it does seem to me that it resonates with something that I used to have to deal with, and that was drug rehabilitation orders in criminal courts, where the engagement of the judge in a sense as a supporter, somebody who was putting trust into somebody and interest into somebody, where it had always been a negative relationship before, was a very powerful thing. And expecting that it wouldn't necessarily be a completely straightforward path.
Thank you, Amanda. Ellie, I'm going to ask you, please, to make the last contribution.
Fine, thank you, Sam. I've been thinking a lot about what to say, and actually I'm going to say this because at the moment we are partway through the 16 days of action against violence against women and girls, and there's been a lot of work going on around how victims of rape and domestic abuse are being let down by the criminal justice system. And one thing that I would like to see is more use of specialist domestic violence at courts. Prosecutions for domestic violence have gone down 19%, and victims of domestic violence, victims of domestic abuse, are being told to pursue their case through the civil courts because the criminal courts are so backed up. There was a survey, a piece of research carried out by Victim Support that was published last week. I asked the question recently to the government how many domestic violence courts they've had over the last 10 years, and the answer was that they don't hold that data centrally. So actually the government haven't got a grip on that. So I would like to see that a priority, and something that I'll be pushing for during this 16 days of action, because I think it's really important. So I wanted to say that. But I think that all of the contributions and all of the ideas have been fantastic. So lots to think about as part of my brief. Sam, whilst listening intently to the answers, I also put in a message to our shadow Northern Ireland Secretary and can confirm that yes, we do very much support a public inquiry into Fianna. So there we go. I've got your answer on that.
Oh well, thank you. That's amazingly efficient. Thanks, Ellie. and thank you to all of our panel for an interesting discussion, and also to attendees. Not as many as I would have liked, but certainly all of you were very, very welcome, and I hope that you too enjoyed it. Thank you very much, and it's our AGM in a few days. Full details of that and how you can join the Society are found on our website, which is www.thesocietyoflabourlawyers.org. So do, I hope, consider joining. Thank you very much, and perhaps see you at the next webinar. Goodbye.